Afternoon and welcome. I'm on the West Coast, and my colleagues that you can see are generally all over the country, but predominantly on the East Coast, suffering the heat with many of you other DCers. We are pleased to present today a webinar on disability rights, a conversation with Human Rights Magazine authors. So each and all of the authors, including the moderator, Robert Dinerstein, we call him Bob. He is an author and also was the issue editor on this magazine. He's going to moderate, and I am just going to lead you into how this all began. So this year, the Human Rights Magazine published 6 issues. Typically, we just publish 4. It's a quarterly magazine. It's the flagship award-winning journal of the Civil Rights and Social Justice section. This year, because of a myriad of issues, we have 6 different magazines, including 2 special issues, one on combating Islamophobia and the other on combating anti-Semitism. This issue that we're going to talk about today with 4 of the outstanding, actually 5 of the outstanding authors, Bob's an author too, is disability rights. This issue is the last issue of Lacey Durham's year, and she has been an outstanding chair. We celebrate her, and I hope you all can join us the end of next week, July 31st, when we celebrate Maya Wiley, who is the Thurgood Marshall 2025 awardee. This webinar is part of a series that is CRSJ's commitment to highlighting and sharing updates on key civil rights and human rights issues through accessible public programming. We're hoping to do one of these readers meet authors and authors meet each other conversations on each of the issues on a going forward basis. As I indicated, Bob Dinerstein is going to lead you through this conversation and work with each and all of our authors. Bob is literally a rock star in this area. He taught for 4 decades at the American University Washington College of Law. He served in pretty much every role in academic and serve-in for Washington College of Law, from dean and director of everything. Most critically, he started the Disability Rights Clinic. And we stand on his shoulders, as well as so many other disability rights legends. Tomorrow, as many of you know, is the 35th anniversary of the ADA. Bob was doing this before the ADA. What I'm so proud of this panel and the ABA Civil Rights and Social Justice section, and I hope you consider joining us if you're not already a member, is that we are scholar advocates. I don't understand how you could be a scholar and not be an advocate, but it happens. And each and all of these authors are. 3 out of the 4 are in the classroom, and Ariana will probably get you into the classroom someday. And they are paying it forward by teaching hundreds of students. Bob has a legacy of students who are out there doing the work. They're making a difference. Bob not only served at his university, but he was on presidential commissions and focused generally, to the extent he has more of a niche, he's doing it all, it would be people with mental disabilities. And he's written about that for the Human Rights Magazine. But what you're going to learn today is the depth and breadth of disability rights And frankly, time is of the essence. As many of you may or may not know, the president issued an executive order yesterday, basically criminalizing homelessness, as well as individuals who are houseless because of mental disabilities. I assumed that might come up in the conversation. Now, a few housekeeping notes. Submit any questions you have through the Q&A. Don't use the chat function. We'll get to as many questions as time allows. If you don't see those Zoom controls, move your mouse down toward the bottom. I'm not sure we have mouses anymore, but move to the bottom of your screen and you'll see that Q&A option. This program is not for CLE credit, but it is being live streamed on the YouTube channel, so you can watch it immediately after this session. A recording of this webinar is going to be online for you to share with your students and colleagues and friends and neighbors and family. Please forward this to anyone who can become part of this conversation and movement. And now I am proud and honored and humbled to turn it over to Bob, who literally started this conversation.
I don't know if it's just my screen, but Francine is frozen at this point. So if is everybody else okay? If so, then I'm gonna start and we'll go from there. So I want to thank Francine for that generous introduction of me. Made me feel kind of old, but there you go. And so my job is primarily to moderate this session, which I will do. I want to introduce briefly who each of the folks are, and you should know they are some of the authors of this volume. There's actually about 10 articles altogether, and I commend the entire issue to you. This is, by the way, the third special themed issue on disability rights that the Human Rights Magazine has put out. The first was in 2000, the second in 2017, and the third is now. We'll be hearing first from Ariana Aboulafia, who currently leads the Disability Rights in Technology Policy Project at the Center for Democracy and Technology here in Washington, where her work focuses on how AI and other emerging technologies have an effect on people with disabilities. Ariana is a disabled attorney who, in her current role at CDT, served prior to her current role, served as an assistant public defender in Miami-Dade County. We'll next be hearing from Dee Dangaran, who is about to return to her native Hawaii, where she will start as an assistant professor of law at the University of Hawaii at Manoa, William S. Richardson School of Law, where she'll be teaching constitutional law, family law, and civil rights courses, so she'll be keeping busy. She's been the director of the Gender Justice at the Rights Behind Bars and is co-chair of the National Trans Bar Association. We'll then be hearing from Kat McFarland, who's Associate Professor of Law and Director of the Disability Law and Policy Program at Syracuse University College of Law. She's a leading expert on civil procedure, civil rights litigation, and disability law. Last but not least is Dr. Robin Powell, who's an Assistant Professor of Law at Stetson University College of Law. Her work focuses on the intersection of disability law, reproductive justice, and public health. So I want to start off, we'll start off with Ariana. And my first question to you, first of all, is give us a short description of what your article is about, and also tell us why it is you wanted to write about this, why this issue was important to you.
Sure. Thanks so much, Bob, and thank you all so much for having me here today. So I'll speak briefly because I know we have lots of really incredible people on this panel. But my article focuses on the intersection of disability rights, AI, and workers' rights. And so specifically, sort of what I talk about are surveillance tools that are put into workers' computers. So things like keystroke monitors or video monitoring software that may use like a webcam, and how they can impact workers with disabilities. So I'll give an example, right? I talk about privacy concerns and how anytime there's an increase in surveillance, there's probably a decrease in privacy. Um, I also talk about kind of disability specific concerns. So how tools that are integrated into employee computers could unfairly flag behavior that's related to a disability. So that could be someone who takes extra time to use a restroom, and there's all sorts of disabilities that could require that, and how those sorts of tools could flag that behavior, although it's disability related and likely protected under the ADA as misconduct. Um, I also talk about sort of worker surveillance tools that are not used on computers, so things that are implemented into environments like warehouses, and how they can increase stress and anxiety and disproportionately impact workers that have mental health disabilities, but also how they can even sort of cause and contribute to physical workplace injuries by sort of demanding extra work in less time. And the last thing that I talk about in the piece is worker surveillance tools that monitor employee health. So you can think about something like a Fitbit, a wearable technology. That are sometimes provided to employees as part of quote unquote optional workplace health and wellness initiatives. And I mentioned again the privacy concerns there because employees by participating in these programs are granting not only their employers, but also the third parties like the tech companies that own or provide the wearable technologies. They're granting those folks all sorts of really private data that can potentially include biometric information. But we also talk about how some people with disabilities, even if they wanted to participate, simply may not be able to participate in these sorts of quote unquote optional challenges. And I use the quote unquotes because it's not optional if some people don't have the option. Um, and how all of these things combined sort of contribute to under-inclusive and exclusionary environments for workers with disabilities. And so very briefly, why I thought it was important. I think that people are really interested in AI. I think people are particularly interested in the impact of AI on people with disabilities. I think that people tend to focus on the ways that AI and AI-enabled tools can benefit people with disabilities, and those benefits are real, but so are the harms and the risks, especially when they're used in these sort of high-stakes rights impacting contexts like employment. And the last thing I'll mention is that I also thought it was important to write about this because I think it's really vital that when people think about, when they conceptualize like what is a worker, that they're also thinking about people with disabilities, because I think that's how you build an inclusive, not only an inclusive workplace environment, but kind of a more inclusive world. So Bob, I'll turn it back to you.
Great. Thank you, Ariana. Yeah, it's amazing that, as has been noted, it's the 35th anniversary of the ADA, and we're still having these conversations about think about people with disabilities when you design, workplaces or various other programs. And the fact is that it sadly continues to be too much of an afterthought. But we're going to come back to everybody. I should have probably said we're going to do kind of a round robin at first, get out what your article is about, and then we're going to come back and ask some more specific questions. So those later on the panel kind of know what's coming. And Dee, you're up next. What is your article about, and why did you want to write about it?
Yes, so I write about the Americans with Disabilities Act and its application to gender dysphoria, which is a diagnosis in the DSM-5 that some transgender people have. This article is really a chance to expand on the normative claim and defense of the claim instead of going deeply into the legal argumentation. I provide a legal history in a recent publication in the Harvard Law Review Forum. And I invited a friend of mine to actually respond to that because I addressed some of the counter arguments to the normative claim within my article. So this article is really a continuation of that back and forth. Here is the link to that Harvard Law Review article that I call Bending Gender. So I'll start with the claim before I get into some of the normative components. So the ADA was passed in 1990 when the DSM-3 was in effect. The ADA Amendments Act was passed in 2008 when DSM-4 was in effect. DSM-5 was published in 2013. And in DSM-5, for the first time since the ADA was passed, gender identity disorder was removed from the DSM and gender dysphoria was added. So there is an exclusion in the ADA And that states the term disability shall not include transvestism, transsexualism, pedophilia, exhibitionism, voyeurism, gender identity disorders not resulting from physical impairments or other sexual behavior disorders. So the entire legal claim that's been adjudicated in the Fourth Circuit Court of Appeals in the success of those making the claim is that gender dysphoria is not gender identity disorder, transvestism, transsexualism, or gender identity disorders not resulting from physical impairments. And that claim, again, has been successful in the Fourth Circuit. No other circuit has reached it. Justice Alito wanted the Supreme Court to take it up just when the Fourth Circuit decided that it would cover gender dysphoria. No other justice agreed. I can see a circuit split on this issue arising eventually. And I think that advocates therefore need to consider why they ought to bring the claim, even despite the fact that there will likely be a circuit split. And so that's where the normative component comes in. There have been some disagreements with the claim on various levels, one of which is that trans people, like LGBT people, should not be perceived as disabled. And I think that's why this conversation is so vital for the disability community to have a conversation about this. While trans people who, under the former gender identity disorder, transgender identity was what was diagnosed as a disability, gender dysphoria has shifted that attention to the actual distress that one feels when their gender expression does not align with their gender sex assigned at birth. So the social impairment, the social model of disability applies directly to gender dysphoria as it does many other disabilities. And so I think I disagree with some others who've been writing about this or have been activists on this for that core reason, that this is not the age of gender identity disorder where identity was what was disabled. There's also the argument that medical gatekeepers stand between someone seeking a claim and receiving a gender dysphoria diagnosis. I think that's remedying the wrong problem. That's an issue that we can face head on without need to hold ourselves back from using the claim altogether. There are many others, but for sake of time, I'll just say the one that really irks me is what I responded to most in this piece. I took a more poetic approach to the introduction to the piece throughout, because Daron Dorfman is a professor who's written an article about disability as metaphor and lists gender dysphoria as an example of disability not used as actual disability, but as metaphor. And while you can talk about trans people with metaphor, and I do, and many trans people do, it's very beautiful to find metaphor in trans identity. I do not think the use of disability when discussing gender dysphoria is a metaphor. It is very real. It is an impairment to many people's functioning. I've focused on litigating people who are behind bars, but whether you're behind bars or not, gender dysphoria can prevent full functioning in society. So it fits perfectly into the definition of disability under the ADA. And so we should not prevent ourselves from using it. And actually, we should embrace it, especially given where other arguments are right now. I'll stop there.
Great. Thank you, Dee. And yes, I'm glad you quoted that language from the ADA, the so-called exclusions that were there. We love to talk about what's good and not so good about the ADA. That was not its finest moment. It was language put in by conservatives who were opposed to the passage of the ADA and was sort of considered to be, kind of the price of getting it passed way back. So it's the linking together of all kinds of identities at that point was very problematic. But it's so interesting that I think your approach to it, and by looking at gender dysphoria and really distinguishing that from what was identified in that unfortunate provision, is really important. So thank you. Now we have Kat McFarlane, and between the time when we started this webinar and now, Kat's been promoted to full professor. Actually, apparently that was true in May, so we congratulate you on that position. And Kat, turn it over to you.
Thank you so much. I'm very grateful to be part of this panel with so many wonderful authors and colleagues. Thank you to Professors Dinerstein and Littman for pulling us all together for such a great event. So I'll talk a little bit about my piece for the magazine Disability Documentation and Disability Discrimination. It's about the way documentation of disability requirements make it quite expensive, time-consuming, and sometimes even impossible for people with disabilities to obtain reasonable accommodations. So the piece explains how the documentation requirement is not statutory. I always hammer this point home with my students. You won't find a documentation requirement for accommodations in the Rehab Act or in the ADA. So the piece goes on to explain how the fact that this has become a prerequisite to obtaining an accommodation medicalizes the process and also is extra statutory and a little bit absurd. So it builds upon a couple of my past articles, including Disability Without Documentation, and it also builds upon a forthcoming piece that I've called Self-Accommodation that describes why people with disabilities forego seeking formal accommodations. So throughout my work, I'm really interested in reflecting the lived experience of people with disabilities. I'm a person with disabilities myself who's started asking for accommodations in law school, needed them as soon as I was diagnosed at 13 months, and struggle with the process. So there's a lot of my own experience and hopefully the experience of other people with disabilities in these pieces as well. So I write about disability documentation because it's relatively understudied, at least in legal scholarship. It exists legally as part of the interactive process. So that means it's an aspect of the accommodations process where employers and employees are supposed to sit down and collaboratively come up with an accommodation. That process gets written about quite favorably in at least the academic literature. You can tell by my tone that I have a slightly different approach to it. So when I originally wrote Disability Without Documentation, I was interested in tracking down where this requirement came from because it's so, again, it medicalizes a process that's supposed to be an informal conversation. And by the informal process, I mean the sit down with your employer. They can then ask for documentation of disability, which is where all of the problems that I'm describing, this is where it comes up legally. So I learned that this documentation requirement in the context of the interactive process was the result of agency guidance. It's not in regulations, as I mentioned, it's not in the statutes themselves. And I think the agency guidance that has led to all these problems is arguably something of a mistake. And then in addition to disability law, I teach constitutional law and everyone's favorite subject, civil procedure. There were aspects of disability documentation, requests for disability documentation, that really troubled me and seemed to contradict really basic principles that are sacrosanct in other areas of the law. And so I'll just give you one example. If you think about, for all of our practitioners out there, how we handle civil discovery and how I teach civil discovery in CivPro, I would never allow a client to give a defendant a blanket release for all medical records, right? I would fight for, if there were discovery that asked for that, I would fight the scope of it. I would ask for a protective order, maybe attorney's eyes only designation. But in the context of requests for reasonable accommodations, employers really frequently ask employees to sign a release for their full medical records or to allow them to pick up the phone, an HR representative, and just chat up an employee's doctor, which is intrusive and again, not in the statute. So aside from the really interesting challenge of tracking down the legal origins of this documentation requirement, I had a sense that this account of at least the interactive process was missing because very few people who write about disability law seem to have the experience of going through an accommodations process, right? Of having to get an accommodation, either because they're not people with disabilities, or I think this is also an important explanation, privileges that are connected to class, gender, race, access to great health care may save you from the humiliation that so many plaintiffs are experiencing with respect to documentation requests. So what we see, even in case law or maybe on the ground, wasn't showing up in the scholarship. And I thought those missing stories really mattered. And then I was writing my first piece about this subject. COVID hit, and people all over the country who had never thought of themselves as disabled needed a doctor's note to justify their request to work from home. In other words, they needed disability documentation in order to get that particular accommodation. And so all of a sudden, people started to experience what disabled people, those who identified as disabled, had known all along. It's a punitive process. It's not one that's imbued with kindness. And so this is the kind of thing I observed that made my research into this topic feel really urgent. So I had a friend with asthma who needed a doctor's note to justify her request to work from home. Her medical records included an asthma diagnosis. She carried an inhaler with her at all times. There was no question that she was high risk for contagious airborne respiratory illness. She fit the definition of disability under the ADA. But the records I just described and the fact that she had an inhaler weren't enough for her employer to grant her an accommodation to work from home during a pandemic that involved a contagious respiratory illness. They needed a doctor's note. So the doctor who prescribed this particular person's asthma medication wasn't taking any appointments at the time that weren't emergencies. It was COVID. Why would you take a non-emergency appointment? And that particular doctor's office had a policy of not filling out forms without seeing someone for an inpatient appointment. And some of these barriers are common outside of an emergency that we experienced at the height of the COVID pandemic. Another thing that happened while I was writing this piece, I was living in Boise, Idaho, and the local major medical group that provided healthcare to about 75% of the metropolitan area's population decided as a matter of policy that they weren't going to provide notes supporting work from home requests during the pandemic. I got this information, I think, in maybe August of 2021. So me and my compromised immune system, I was on 2 forms of chemotherapeutic treatment at the time, couldn't get a doctor's note to work from home, and so on and so forth. So the matter was urgent then, it remains urgent now. People need accommodations to work maybe pain-free just to get their essential functions done. And maybe you can work without accommodations, but if you don't have accommodations, you might not be able to perform your essential functions and you may get terminated, right? On a positive note, I'll say that this article and my research surrounding this article and this line of research has really gotten a positive reception. I had the privilege of working at the Department of Education's Office for Civil Rights for a year. I see some of my former brilliant colleagues have signed on. You know who you are. You're some of the best lawyers I ever worked with. And they let me talk this research out and talk about the implications of some of what was missing in the regulations. And before we changed administrations, there was some guidance that went out that reflected the fact that you don't need documentation to grant a child in the K through 12 context or higher ed an accommodation. You don't need them to produce medical records. So I've never had such a positive response to a piece of legal scholarship. I've heard from people literally all over the world. And I think what happened with this line of thought is that people felt seen by the arguments or just the recognition of what the process is like. And I'll talk more as the event continues. But again, it's so nice to be part of this panel with brilliant co-panelists and organizers. Thank you for having me.
Thank you, Kat. A lot to talk about. There's like 20 questions I want to add, but I'm going to stick to what we're doing. So, Robin, you're up next.
Thank you, and thanks for everyone that's attending on a Friday afternoon. I'm very impressed to see everyone here. So my article is looking at how the Dobbs decision has really, I think, created sort of this perfect storm of threats to people with disabilities, sort of reproductive autonomy, especially, I think, and really concerningly in the context of Trump's return to the presidency. So in my article and sort of my scholarship, I think more broadly, I trace a direct through line from the 1927 Buck v. Bell decision, which really gave the blessing to states to forcibly sterilize people with disabilities and others that were deemed sort of unfit for reproduction, all the way through to today's abortion restrictions. And while both represent forms of state control, I think, over the bodies of people with disabilities and other marginalized communities, although of course they operate through sort of different mechanisms. And so my piece is applying a reproductive justice framework to really highlight and illustrate sort of how that for people with disabilities in particular, abortion access isn't really abstract. It's really often about survival. And so people with disabilities face higher rates of sexual violence. They often have medical conditions that might make pregnancy more dangerous or even life-threatening. and they frequently live under guardianship regimes where we're giving others control over one's medical decisions and their bodies more broadly. So when you combine abortion bans with those realities, you get this system that's effectively, I think, stripping people with disabilities of any meaningful reproductive autonomy. And so in my article and sort of scholarship, again, more broadly, I'm arguing that we really cannot understand sort of this current moment that we're in without really grappling with America's history of eugenics. And that protecting abortion access for disabled people is not a side issue. It's really a fundamental test, I think, of whether we believe that people with disabilities deserve bodily autonomy. And so I wrote this probably for the obvious reasons that we are in quite the moment. But I also wrote it because people with disabilities and our voices are consistently, I think, erased from reproductive rights conversations, despite, as I said, facing some of the most severe consequences from these restrictions. And when legal advocates challenge abortion bans, they really rarely center, I think, the experiences of people with disabilities. And I think that's really a massive strategic failure and really something that we need to be thinking about. So the timing, therefore, really, I think, felt pretty urgent. And with Trump back in office, and I think a Supreme Court that is clearly inclined to sort of further erode individual rights, we're seeing sort of what I think is an acceleration of policies that frighteningly, I think, echo our country's eugenic past. And for many people with disabilities, as I've said, sort of pregnancy isn't just challenging. It can be medically contraindicated, and really, it can be a matter of life or death. So when abortion then becomes sort of inaccessible, we as people with disabilities are essentially told, I think, that our lives don't matter. And so I also in my article didn't want to just sort of highlight this problem, but I also want to provide sort of this concrete framework for legal advocates. And current litigation regarding abortion, I think, really fails to adequately address how abortion bans violate the rights of people with disabilities. And I think we need to explicitly integrate disability justice principles into this litigation and into these challenges. And again, it's only going to become more urgent. And last, I would say that I felt really, I think, compelled to sort of name what we're all seeing, which is that the logic of Buck v. Bell is resurfacing. And so the Supreme Court, and I'll talk about this later, has never formally overturned that decision. And I think it's eugenic reasoning, essentially, that society has sort of this legitimate interest in controlling certain people's reproduction really does persist, maybe even in more subtle forms, although I think they're becoming less subtle by the moment. And I think that as attorneys, as legal professionals, we need to be actively rejecting that foundation rather than sort of pretending it doesn't exist, which is what I think we've done as a whole for far too long. And so I think this is about whether we're going to be willing to defend the principle that all people deserve reproductive autonomy, or whether we're essentially going to continue to treat people with disabilities in our bodies as sort of this acceptable collateral damage. And so I would really try to urge those in this area to really, really consider and engage with people with disabilities in this movement, because I think it can strategically be smart, and I think it's just something that is far well overdue at this point. Thank you.
Thanks, Robin. And you know, one of the points I made in the introduction is that some of the issues, really all the issues that you are talking about, are issues that have come up relatively later, if you will, in the 35-year, history of the ADA, probably with the exception of the reasonable accommodation stuff that Kat described. Although even there, because of other case law, it took a while for, there hasn't been the kind of development of the law on reasonable accommodations you might expect. But, I think some of the particularly like some of the issues, Robin, you're dealing with, people weren't thinking about people with disabilities as having less sexual lives or being parents or doing any of those kinds of things. And so of course, that was always true, but I think there's greater recognition now. And so it's great that you focused on that. So I'm going to talk briefly about the article that I wrote, which was about the 25th anniversary of the Olmstead case, Olmstead versus LC, which was a 25th anniversary last year. and in particular, the role of federal enforcement of Olmstead. Olmstead has been enforced by some terrific private lawyers as well as the government. And one of my concerns in the piece is whether the federal government is still going to be enforcing Olmstead in light of some of the things that already have happened. So I think probably most of the people, certainly on this panel, but probably even our attendees, are familiar generally with the Olmstead case. It was a case out of Georgia about two women who were in and out of an institution in Georgia. They had intellectual disability as well as some psychosocial disability. They sometimes were in the community, sometimes in the institution, but were not sufficiently served in the institution. They brought suit. It was an individual suit on behalf of just those two under Title II of the ADA. And in the decision, which interestingly was issued the same day as some really negative ADA decisions, the Sutton case, the so-called Sutton trilogy. In Olmstead, Justice Ginsburg, writing for plurality, basically the majority of the court, said that, look, institutionalization is a form of discrimination that may seem obvious to people, but it wasn't always so clear, and that it denies people access to various services and things that they could get in the community, and it consequently is discriminatory. And the court came up with a three-part test to determine whether or not somebody's rights were being violated under Title II, and particularly under a one-sentence regulation, the so-called integration mandate. And that was to say that if the individual with a disability, if professionals who were evaluating that person thought that the person could survive in the community, if the person did not oppose placement in a community program, and if there were community services available, given the state's obligation to also provide services to others, then placement had to occur. And so that's what the court decided. There was some dissents in the case, but it was pretty straightforward. What was really fascinating about it, and I've written about this previously, is that immediately in the last years of the Clinton administration, the administration jumped on the case to say to all the states, they sent out letters to the governors and to the heads of the state healthcare financing agencies saying, we are going to enforce this case. This is now federal policy. So you better take a look at what services you're providing, and you need to have plans for how you're going to both get people out of institutions and also keep people from going into institutions. There was some beginning enthusiasm in the Bush administration as well for enforcing the Olmstead and the ADA more generally. I think that flagged after a while, but at least it wasn't explicitly turned back. A huge boost to enforcement came during the Obama administration, and I talk about briefly the efforts they made and people that they hired, Sam Bagenstos and Eve Hill and others who were really critical in getting states to comply with Olmstead. A number of investigations, statewide investigations, were brought against states with multiple institutions saying you've got to do better to get people out of those institutions. We go to Trump 1, where as we're seeing, I guess, in many other areas, they didn't do any great things, but they weren't nearly as bad as they could have been. They actually reinforced a commitment to Olmstead in the middle of the decision of the term, and brought at least one or two investigations that during that period, I would say, cutting back a little bit on the kind of relief that justice had been seeking, but not substantially. Biden administration, again, we seem to be flip-flopping. They did a number of ways of enforcing the statute, the decision, and they did a quite nice job with that. They were also doing other things on the regulatory side. Kat mentioned one, Department of Education. Also, as you probably know, the Department of Health and Human Services engaged in a very extensive process in revising the 504 regulations that under their agency. And at the end of the Biden administration, there were a number of investigations that were begun. And then we have the Trump administration coming in, which, first of all, put a freeze on new investigations or actually any activity. It's not so unusual in new administrations. That was the case when I was at Justice back in the end of the Carter administration. The Reagan administration came in. But it all depends on what the purpose of the freeze is and how long it's going to go. And there's real concerns about that. The very big concern, given that the primary enforcer of Olmstead has been the Department of Justice, and within the Department of Justice, the Civil Rights Division, and within the Civil Rights Division, the Disability Rights Section and the Special Litigation Section. As I'm sure you've heard, there are estimates that perhaps as many as 70% of the lawyers in the Civil Rights Division will be leaving or have left. Some will have taken early retirement. Some will have been, reassigned to other positions, and some will have been riffed. And having again worked in that division, left that division at an earlier time that we thought was politically fraught. By comparison, it doesn't seem so now. That's extraordinary because, as we've seen throughout the government, even when, excuse me, even when you don't explicitly say change policy or stop enforcing it, if you take away all the people who know anything about enforcing it, you're going to make it pretty much impossible to do anything about that. And I think that one of the things that we're seeing in the disability area is, unlike some other civil rights areas or groups with marginalized people, there isn't as much direct hit on disability, but as an indirect hit, it's pretty substantial. So, if you close 7 out of the 10 regional office of civil rights offices, if you have 70% of the civil rights division people leaving, if you undo the Department of Education while claiming not to change what you're doing in special education. All that really doesn't make any sense. And unfortunately, of course, not to mention even things like Medicaid cuts, we're going to really see some awful, awful things. And that would really be a shame because with regard to Olmstead enforcement, I mean, not only was justice active by filing, doing investigations, filing letters of findings, statements of interest in ongoing litigation, amicus briefs, guidances, all the ways in which, as well as litigation, all the ways in which they could enforce the law. That if those are not there, it puts quite a burden on already overburdened private entities, legal services offices, protection and advocacy offices, private attorneys, to try to bring these cases. Anybody who's done this kind of institutional reform work knows that these cases take many, many years to resolve. And there are just too few entities out there. And the benefit that the government brings, apart from usually having experience and continuity, is resources. And if they're not there doing this, it's going to be a lot harder. In addition, there are some other developments, which I'll just say briefly mention. There's most of the case law under post-Olmstead has been positive. There is, however, the Fifth Circuit decision in U.S. versus Mississippi, a really terrible decision that calls into question some aspects of Olmstead, and particularly those related to applying to people who are not yet institutionalized but are in danger of that. That case was not appealed, thankfully, because I think there'd be concerns of what the Supreme Court would do, but nevertheless stands as the law of the Fifth Circuit, and that's a problem. There's an ongoing case, folks may be aware, from Texas, now called Texas versus Kennedy, that raises questions where the attorney generals from about 17 states have filed a complaint that, among other things, raised questions about whether the integration mandate regulation and Olmstead are still a good law. So we'll have to see how those operate, and we have lots of concerns, and it's just one of many, many things that we are worried about in a time when we should be celebrating decisions like Olmstead and other anniversaries of importance in the disability rights area. So with that, I'm going to start back with Ariana and ask you the following question. As you mentioned now, and as your article does, you discuss a number of ways in which people with disabilities are facing intrusive surveillance in the workplace. And I'd like to ask you to expand just a little bit on this topic and talk about some of the challenges that new technologies present to people with disabilities, and thinking particularly of ChatGPT and AI issues because of those things. And I think I've mentioned to you, the Wall Street Journal recently had an article within the last week. He had dangerous delusions. ChatGPT admitted it and made them worse. And one of the things the article talked about was this man who did seem to have some delusional behavior, but he was getting all this overly positive reinforcement from ChatGPT, which made him think that his ideas, which had to do with things that could be faster than the speed of light, and went on, and eventually they came to ask ChatGPT whether or not you're being too positive with this, and ChatGPT kind of came out and said, "Yeah, we probably are feeding these delusions and probably being too positive." I mean, it's just very bizarre. But I'm just curious, more generally, Ariana, what you think about some of these technologies.
Sure, yeah. So I can talk a little bit about this. So that Wall Street Journal piece, there's actually not a dissimilar piece by Kashmir Hill in the New York Times that talks about people with mental health disabilities and how they have been impacted by not just AI as like a broad sense, but like kind of specifically, we're talking about large language models, LLMs, and social agents, which are these sorts of, you can think of them as these chatbots that chat back to you, right? Social agents are kind of a subset of large language models that are specifically engineered to kind of like seem like your friend or seem like a partner or seem like a teacher or something like that, right? And they're all sort of structured in different ways. Some of them, disturbingly for the disability context in particular, are they sort of are structured as like therapists almost, right? And there does seem to be at least anecdotal evidence that in the social agent context that people with disabilities may be disproportionately impacted, particularly people that have potentially mental health disabilities or intellectual developmental disabilities, disproportionately impacted by some of the negative outcomes of those chatbots. The phenomenon that you're describing that's kind of issued in the Wall Street Journal piece about someone sort of putting in all this information and the AI sort of egging them on, we sort of think about that in the context of what we call sycophantic AI, which is that these tools are structured so that you don't leave, right? And this is not specific to ChatGPT, to be clear, right? And so the quickest way to get someone to leave, right? And you can think about it even in context of like a person-to-person conversation. The quickest way to get someone to leave is to upset them, right? And so the chatbots don't want to upset the user, and so sometimes they wind up being what we refer to again as like sycophantic, right? That they egg you on, keep you in the conversation, and that can potentially have some effects for folks who may be going through a mental health crisis or something like that. And that's kind of what that Wall Street Journal piece is about, and similarly, Kashmir Hill's piece in the New York Times. But you know, I have actually, my organization, the Center for Democracy and Technology, we've done some research on LLMs and chatbots, not in the context of social agents and the mental health impacts, but just on the context of like misinformation, right? And so what we chose to, this is a study that we put out last year, and we chose to focus on basically how these chatbots would respond to queries on voting with a disability. And for some of y'all probably know this, but the sorts of voting types that are available for people with disabilities varies on a state by state basis, right? So some states have curbside voting. Some states, 13 states, allow internet voting for print disabled voters. The laws as to voting rights for folks under guardianship significantly varies depending on a state by state basis, right? And so this is an area of law that's deeply, deeply confusing. And because a lot of chatbots can be accessed like on individual phones where someone's accessibility requirements are already put in, it's totally possible and probably even likely that some folks with disabilities are asking their chatbots these sorts of questions. And so we were interested to see, and we put this out prior to the election last year, but we were interested to see sort of, is this providing information that's correct on one hand? And then secondarily, if it's providing information that's wrong, could that information dissuade someone from exercising their right to vote? And I'll give an example of how that could happen, right? I used to live in a state that allowed curbside voting. I moved to a new state. I asked ChatGPT, does my current state allow curbside voting? And it says, yes, just show up day of. And I show up day of, and it turns out my state does not allow curbside voting. Well, now how can I vote if that's what I really needed? And the time has passed for me to do an absentee ballot, right? And so I'll give sort of very quick statistics. So over a third of answers included incorrect information. And over a quarter of responses could dissuade or impact the ability of a person with a disability to exercise their right to vote, right? And that secondary thing, insofar as like determining whether or not it would dissuade someone from voting, that was determined by, we had both experts in disability and also experts in election and elections administration sort of on this team looking at this. And so the chatbots, again, right, there's all sorts of different ways to think about this. You can think about this from an information accuracy perspective or information integrity. You can think about it from a perspective of social agents, and that's just the LLMs, right? But there are other tools, right? And I'll give another example. The tools I talk about in the workplace context in this article, there are similar tools that are used in the educational context. There's remote proctoring software that uses cameras to try to prevent cheating. And just very similarly to the tools I mentioned in the employment context in my piece, these sorts of tools also can flag unfairly disability-related behavior, like let's say an atypical eye movement. It can flag that as misconduct, or in the educational context as cheating. And we've also put out research, I believe this research came out 2 years ago now, that teachers of students with disabilities, so special education classrooms, and parents of students with IEP and 504 plans are more likely to report that their students that they interact with are being disciplined for either using ChatGPT or being accused of using ChatGPT, right? And so even again, like just going back to the ChatGPT, the LLMs, and that I don't use this example solely because you asked me, Bob, but it's also because LLMs are something that I think really made a lot of people, when they sort of hit the market in 2022, think like, wow, the AI revolution is here, right? And LLMs are just a type of AI, and they're just a type of tool that impacts people with disabilities in all sorts of contexts, in work and in education and in healthcare. But their impact absolutely can be seen and can be sort of dissected from all sorts of angles. And so one of the things I really try to do in my work is to raise awareness of like the impacts of these tools on people with disabilities and how these things impact us, and equip advocates and people with disabilities with the tools to try to mitigate and minimize some of the risks and potential harms. And I'll turn it back to you.
Great, thank you. Yeah, it's a fascinating issue, and the history of techno of how technology can help or hinder people with disabilities is just rife with, right? There's so many things that are now possible because of technology, and yet we continue to have inaccessible technology out there that really prevents that from happening. So thank you for the depth of the work you're doing. Dee, in your article, you start your article and you talk about a number of early victories in the area that you're describing, trans rights, in particular requiring prisons to provide hormone therapy to trans inmates who it was in their custody. Subsequent to your writing of the article, of course, the Supreme Court decided U.S. versus Scrimetti, rejecting equal protection challenge to Tennessee's law that was banning gender-affirming care. So I wonder whether you can tell us a little bit about Scrimetti, not in great detail, but sort of the highlights of it. And are you still sanguine about how courts are treating these kinds of issues? Again, we've seen a lot of back and forth between the Supreme Court and lower courts on a number of initiatives of the Trump administration. But I'm curious where you see things going with regard to litigation on behalf of trans people.
Yes, so first, I don't want anything to get to this Supreme Court, just to be clear. I think it's been hopeful to see lower courts' responses. But just the Scrimetti decision took discrimination against gender dysphoria as a discrimination against medical use, not a discrimination against sex classification. And so that is the core takeaway in a nutshell that will be relevant moving forward for disability claims. So the court's taking up in October term 2025 two sports cases, Little versus Hecox and West Virginia versus BPJ. So trans rights will be on the agenda again. And I think in those contexts, it will be harder to say the discrimination against trans girls playing on girls' teams is about something other than sex. Perhaps they'll find another out to find rational basis review. But here, when the actual medical treatments that treat gender-affirming care are defined as discrimination against medical use instead of sex, I could actually see how the court got there. And so under the rational basis review, once they decided we're not going to be doing intermediate scrutiny and they did rational basis, this is the language that I think I'm nervous about moving forward. Even outside of Scrimetti was about youth, but I think there are implications for adults, and there are implications as well for the people in prison in the Eighth Amendment context. So Tennessee concluded that there is an ongoing debate among medical experts regarding the risks and benefits associated with administering specific forms of gender-affirming care. And so that language, if the court decides that ongoing dispute will apply in the Eighth Amendment context in a prison case, for example, with the challenges against Trump's bans in the BOP on gender affirming care or even housing placement, there is a chance that the court will side with the Fifth Circuit, which has said we don't need to do. There's been a circuit split, I should say, in the Eighth Amendment context since 2019, right? So there are companion claims to the equal protection claim that I've brought and will be litigated despite Scrimetti taking equal protection really off the table. And that's the Eighth Amendment and the ADA. And so in Gibson versus Collier, the Fifth Circuit in 2019 said that there's no Eighth Amendment violation for denying surgery, gender-affirming surgery, as a blanket ban because of ongoing controversy, using that same language that Tennessee used as their rationale to prevent it from children. The Ninth Circuit, however, found that that specific sort of blanket ban on surgery offends the Eighth Amendment because there's a need for an individualized determination under the Eighth Amendment. That's the medically necessary inquiry. There's, the objective inquiry as to the medical necessity of the care as to that person. So a blanket ban, the argument is going to be over whether a blanket ban is justified. And it's just a different question that the Supreme Court will face if it's going to take up an Eighth Amendment case. But I think that medical necessity standard is just a different one altogether from equal protection. So Scrimetti doesn't affect it 100%, but I do think that it gives some support to those who are going to put their stake in this ongoing debate rationale for why even a blanket ban will be justified. I think the ADA claim, though, survives Scrimetti and maybe gives us even more reason to pursue it. Those in the free world have brought certain claims under the ADA, but I think we've seen it have more purchase in prison because it's so powerful there compared to the Eighth Amendment being kind of a weaker grounds for litigation. Now that equal protection is a weaker grounds for litigation, I think that folks in the free world may be considering the ADA claim, which is really teed up nicely by Scrimetti, the same way that the ADA made sense after Cleburne. If we are in a rational basis world, the ADA is there to say, well, you've framed this as a medical use. It's actually a disability, and that disability should actually get much higher scrutiny than rational basis. So that's where I hope that we go, and we'll just sort of see how that plays out.
Great, thank you for that. Kat, you argue that, and you're not alone in this, that the ADA reflects a social model of disability as compared to a medical model of disability. But aren't there elements of the medical model in the statute itself? I'm specifically here thinking of the definition of disability, which is a physical or mental impairment that substantially limits one or more of the major life activities or actually major bodily functions of the individual. And if so, how at all does that affect your argument?
Thanks for this question. It's one of the better ones I've ever gotten about this piece. So I'll start with, I think the ADA Amendments Act is a move away from the medical model of disability, even if it's not expressly, in that it says, stop focusing on whether someone is or isn't disabled. I think we can fairly read that as a reminder to stop asking for things like medical records and obsessing over whether the category fits or not. A lot of the way that the law and employers, and this happens in higher ed, that obsession about whether someone is or isn't disabled often turns on whether they have enough proof of whether they are or are not disabled. That said, I think from a policy perspective, I made a big pitch in my original article that we can have disability without documentation. That's not a great place to start if you're writing a regulation, for example. And there are places where medical documentation in the context of ADA claims makes sense. So for example, a trial, if a plaintiff has to prove that they have a disability in the context of a disability discrimination claim, let's say that they argue that they were fired as a result of their disability, that makes sense to me. Even at trial in connection with a failure to accommodate claim. But the difference in those contexts is that we have rules of evidence that decide what comes in or doesn't. During the course of litigation, we have the ability to seek protective orders or otherwise limit the scope of discovery. But importing the medicalization that might exist in the terms physical or mental impairment into and the definition of disability into the interactive process, I think that doesn't necessarily then allow us to accept all of the sort of medical records requests that are happening in that space. And so my main argument is, and I think I can separate the way that medical records, or at least the involvement of healthcare providers, are still relevant to the definition of disability, that they're just not as relevant, or maybe at all relevant, to the interactive process, right? And so my focus is on an argument that the interactive process is particularly over medicalized in such a way, it's closed, behind closed doors process that's turned into a punitive experience that has nothing to do with the social model of disabilities. In fact, that records requests become weaponized. So maybe that's even beyond the medical model. It's something like the let's harass you model of engaging with disability. And then I'll also say that we really have, just in general, a crisis of access to medical care right now. Let's say even if you have great insurance, you're going to have to wait 6 months to get in to see a specialist. So asking people to engage with a healthcare provider just to get an accommodation means that they're not going to get them for 6 months. Disabled people are going to get kicked off Medicaid. I worry about all of our wonderful federal employees who are getting fired and losing their health insurance. And then, of course, the impact of medical racism and medical sexism. We know all of these things, and yet we send people into healthcare spaces and expect that they're going to be believed with respect to things we know they're not believed about already. And then we also expect them to be able to get proof of disability from doctors that won't even prescribe appropriate pain medication. So I think we've, in addition to over medicalizing, we've sort of created an artificial vision of what medical care, healthcare really looks like for everyone, for people with disabilities and all those intersectional forms of discrimination that they experience, intersectional identities as well. So I'd love a more realistic understanding of how we all interact with healthcare and see that phased into the interactive process, while also, taking your very good point that there is reference to medicine and healthcare in the definition of disability.
Yeah, and of course, we also know, I think, again, everybody in this panel knows this, and probably many on the call, but one of the really interesting parts of the ADA definition of disability, which is also the 504 definition, is that it covers people who are regarded as having a disability, even if you actually don't have it, because others respond to you that way. And that really does seem to me to be kind of a classic example of the social model. You're also, of course, quite right to point out that the 2008 amendments pretty much said, look, we've been spending much too much time on that primary question of, do you have a disability? We ought to get past that and actually get to the merits of cases. So I think that's absolutely right. But there is a little bit of that kind of back and forth in that definition. Robin, I'm gonna I hope this doesn't mess you up, but I'm going to go to question 2 for you rather than question 1, if that's okay. So you may have noted this recent case in Georgia where a hospital maintained a brain dead woman on life support so that she could deliver her baby. Legislators in Georgia differed. Some said this was required under their new abortion statute. Some said it wasn't, but the hospital apparently felt that they had no choice but to do this. I wonder whether you're concerned there might be some additional cases like that with women with disabilities who are being forced to keep their pregnancy and have it go to term, even though they may not want to do that, but because, again, of concerns about that. I wonder whether that's an issue that has hit your radar screen.
Yeah, and thanks for that question. I think the Georgia case, does in many ways sort of represent a precursor to sort of broader threats in the sort of post-Dobbs environment. And I think that we see that there's sort of this real danger that Dobbs is essentially opening the door to similar cases where a pregnant person's health, consent, or status is going to be subordinated to the interest of the fetus, or ostensibly to the interest of the fetus. And people with disabilities, I think, especially those that are living in either institutionalized settings or under guardianship, or who have somehow been deemed to lack sort of that decision-making capacity, are going to be particularly vulnerable within this context. And so I think that there is a lot of sort of carryover, people with disabilities, again, sort of those that are institutionalized, guardianship, etc., they're going to face increased pressure to essentially remain pregnant despite perhaps their own personal, their own medical or legal concerns, and they might not have sort of the resources to be able to assert their own rights. And so the intersection of sort of that reproductive, a rather restrictive abortion laws with sort of the existing guardianship regime or institutionalization, I think is creating sort of that, what I called at the beginning, sort of that perfect storm, but I think it is for reproductive coercion. And when we have sort of these legal frameworks already discounting people with disabilities' own autonomy, when we add sort of fetal rights into the equation, I think we're further diminishing the capacity of people with disabilities in their agency over their own bodies. And so I think in many ways this sort of underscores sort of the real problem with these laws. And I also think that this terrible situation in Georgia reminds me in many ways of sort of this paper I just had published called Disabling Abortion Bans, which essentially talks about how abortion bans and sort of these health exceptions aren't very helpful at all. And that they exclude, amongst other things, people with disabilities in very clear ways to me. And so I think that we can use this case in Georgia to really sort of underscore sort of the problems with abortion bans, particularly as I think they affect people with disabilities. I would also just say, to sort of answer someone's question that came in, I'm going to take the moment just to answer because I think it's sort of tangentially at least related. But there's always this question. It's something I have tried to get at, not so much in this paper, but in other papers, sort of how do we counter sort of that anti-abortion rights movement's talking points that essentially abortion restrictions essentially protect people with disabilities. And specifically, they talk about sort of fetuses that have disability diagnoses. And I think that there is a real problem with that. So first of all, that whole idea totally discounts the fact that it's actual people with disabilities, not fetuses with hypothetical diagnoses, that are impacted by abortion bans. And so we need to really center actual living beings as sort of those that need to be considered. And to push back a little further, I think that both the anti-rights movement and the pro-abortion rights movement have both done a terrible job of really considering people with disabilities. So I don't want to just cover that side either. I think that both have done it in very harmful ways, using disability to sort of further their cause. In the area of sort of the pro-abortion rights community, I would say that the movement has used disability as sort of justification for expanding abortion rights. You know, I'm thinking about the Zika virus, for example, when even sort of those that would traditionally be very anti-abortion seem to be, maybe we can do abortion if we're talking about Zika virus. The converse side, of course, then is that the anti-abortion side has essentially argued, you know, how could you possibly end the life of this poor disabled person? Look how cute they are. You know, how, you know, bringing cute babies to state houses saying, look at how cute, how could you not allow them to live? And I would argue that, you know, first of all, those same individuals are the ones cutting all kinds of disability rights protections and services. So I think that they're concerned maybe with fetuses with disability diagnoses, but not disabled people. And so let's recognize that. But also, I think this pushes for really the importance of reproductive justice. And so if we are going to embrace a reproductive justice approach to this, we're going to ensure that all people feel and have sort of those adequate supports, resources, etc. And they also are receiving sort of comprehensive information being provided for connections to their community, material support, and so that they can make a genuine choice. Because I worry sometimes that people aren't being given the opportunity to actually make a choice. They feel like they have no real option. You know, they know that there are wait lists for disability services. They're fed all of these biases about people with disabilities. They're not given the accurate information. So if we want to embrace this issue from a reproductive justice approach, that's where we need to be centering. At the same point, and I want to end with this, disability rights and justice more broadly is based on two really strong principles: self-determination and bodily autonomy. And so I think that at the end of the day, we do need to embrace sort of what that means. And that does mean embracing and understanding sort of the right to make one's decision about their own reproductive autonomy. And I say that, I think, as someone who has a disability, whose disability could be identified in an ultrasound now. And so, of course, people are saying, well, wouldn't you worry about not wanting to exist? And of course, the idea that I wouldn't exist because of that finding, of course, is horrible, right? Like, I want to live, of course. At the same point, I value bodily autonomy and self-determination. And I think that everyone needs to feel and have those supports so that they can make whatever the best decision is for themselves. And again, at the end of the day, it is actual people with disabilities that are being impacted.
Yeah, thank you for that answer and for also addressing the question in the Q&A. And I'm also glad you referenced something which I've been looking at for a number of years, which is the lack of good information that expected parents get about certain disabilities. So if there's a screening test for Down syndrome and you don't know much about Down syndrome, and your ideas about it are either non-existent or quite dated, you may not be in the best position to make the decision that you ought to. But that's different from coercing a decision in a particular direction, which I think is problematic, and certainly not wanting the state to do that. But it's been an interesting debate also, is I think politically before Dobbs was a way that some states thought, well, here's a way to chip away at Roe. We'll go after abortion on the basis of a finding of Down syndrome. That's where people can get behind that. And with Dobbs, frankly, the political necessity of that, I think, from the right is less, although not completely gone. But
yeah, and I would just add one thing to that. I think someone just pointed out sort of we live in a society which devalues people with disabilities, and I think that is absolutely true. But even when you hear sort of how doctors approach this, so if there is a finding through screening, they come in and they tell you, we have terrible news. This is so tragic. I'm so, so sorry. And that's already teeing up sort of that, oh my goodness, I need to do something. This is really bad. And so even the framing when you're getting those test results becomes sort of this self-fulfilling prophecy in many ways. Sort of it then leads to the outcome. And so if we want to really address this, again, it's providing the right information, providing the right supports, and just framing it accurately. And we know that medical ableism is a real problem. So I think that also tees into this.
Yeah, that absolutely. And a colleague I know wrote about, they did a study about how many expectant parents, given this information, it was presented with, I'm sorry to tell you this, or I regret, or this is horrible. And again, that kind of tees up a certain way of looking at these issues, which is really unfortunate, I think, for people making the decision that's really best for them and their family.
Right.
Ariana, I'm going to go back to you. Again, we could spend 90 minutes on each one of these, so I appreciate people's patience in this. And I'm going to jump to question 3 for you. So we have a lot of workness wellness programs, and you talked about this a bit in your piece, that encourage employee health and taking part in particular programs. As you say, they may be supposedly voluntary, but often can become required effectively. But even when these are well-intentioned programs, they can be overly intrusive for people with disabilities and may force them into seeking treatment that they wouldn't otherwise choose to do. And I just wonder whether you have a sense of what the best practices might be in this domain to both make services available on the one hand, but not make it even indirectly coercive to people.
Sure, yeah. So the first thing I'll note about these kind of workplace wearable, quote unquote, optional programs, I think it's kind of maybe concretizing to kind of give an example. So some companies, corporations, organizations, et cetera, they may have, let's say, a program for employees where they provide everyone with a Fitbit and they say, if you take 5,000 steps per day, then there's going to be some sort of incentive, right? I think they see it as optional for that reason, right? Because there's an incentive. Meaning if you don't complete it, then you're just where you were before. First of all, not every program operates that way. Some actually disincentivize you for not participating, which is the opposite structure, but that's when you start to really think about kind of like it being inherently discriminatory. The other thing I'll say, just as a point of order, right, is that there are some of these challenges that some people with certain disabilities are simply not going to be able to do, right? And an example, right, is that someone who, let's say there was a heart rate challenge that says, if you can get your heart rate below X number for X minutes per day, then that's your incentive, right? And someone who has POTS, postural orthostatic tachycardia syndrome, which is not uncommon as a comorbidity with things like long COVID, right? They may not be able to participate in that. Even the step count one, right? As an example, someone who is a wheelchair user, someone who has, mobility differences, they may not be able to reach that number of steps ever, um, much less sort of on a extended scale, such as required for these types of programs. So the reason I say all of that is because, and the other thing I'll note too is that under the Biden administration, the EEOC did in fact release guidance on these wearable workplace programs, specifically talking about their relation to workers with disabilities. That guidance, last time I checked, is not available on the website anymore. I'm unsure if that means that it was rescinded or if it's just not like visible. But it did exist at one point. And so this is something that people have been thinking about. I think from my perspective as a disability advocate, that the best practice, if you're someone at a workplace who's like in charge of these things, would be probably not to have them, because they open up all of these concerns, again, regarding inclusion, but also secondarily because of the privacy issues, right? Because when you give information to a wearable technology company, you don't necessarily then know, or an employee may not be made aware of who it then goes to after that, right? Then potentially it's sold to a data broker, or then potentially it is made available to the federal government, right? Like we just don't know. I don't think in the vast majority of these programs that employers are making their employees aware of what happens to the data that's being kind of gleaned via their participation in this sort of program, right? But the other thing that I'll say is that there are some people with disabilities, and I'll use folks who have mobility differences kind of as an example, right? That it may not appear that they have a disability, right? An employer may not know. And so even if you take kind of an idea of, okay, well, I want to have this program, but I want to be inclusive. So I'm going to go to my employees that I know are disabled or that are visibly disabled, and I'll ask them, how would they like me to do it? Or is there an alternative or something like that, right? But there are tons of employees that have disabilities that choose not to disclose. And that may not, let's say, need an accommodation in their regular sort of day-to-day work, which these wearable programs are not the regular day-to-day work, right? Like they're for most things, right? There's something a little bit different. And this is something, as a step back too, that we also see with the worker surveillance tools as well, right? Is that someone may not have disclosed a disability, and then these worker surveillance tools will flag that behavior. And so what I mentioned in the piece that I wrote for the magazine is that, like, you have an employee who may not know that they're being surveilled, being flagged to an employer that may not know that they have a disability, right? And those sorts of things combined, especially when AI is also being integrated into HR processes that help determine sort of discipline and the next step, right? All of those things sort of cascade upon each other and create an environment that's maybe not the best for workers with disabilities, right? And so when I think about kind of crafting a a program that would be inclusive to people with disabilities, I think it's really, really difficult to do. Again, partially because that decision whether or not to disclose your disability in the context of employment is a personal one. And so I think that making an inclusive program would be very, very difficult. But the thing that I will say that is kind of the lodestar of all of my work is that people with disabilities should be centered in all of this, right? In the production of technologies, the development of technologies, and the implementation of any sort of program that relies on a technology and the auditing of technologies, right? And I think that that centering of people with disabilities needs to be intentional and intersectional, right? So it needs to include disabled people of color and disabled queer and trans people, because they interact both with these systems, right? Like employment or healthcare or education, and the technologies that are being integrated into the systems, right? And they do so differently. And that's kind of one reason why creating like a cross-disability policy solution for these things is a little bit difficult and that's sort of why I say that like the best practice genuinely may be just to pass on it entirely. But if you really feel the need to do it, being aware of the fact that it's quite difficult, being aware of the issues surrounding disclosure, and also being really, really intentional about intersectional inclusion, I think would be good first steps.
Yeah, and I'm glad, I think really all of you, both today and in your articles, are really, have emphasized the importance of centering people with disabilities within the various issues that we're talking about. The byword of nothing about us without us is really an important one. And I think too many of our policies have been done, on behalf of, even when they're seemingly well-intentioned, as opposed to with or by people with disabilities. We do have a couple of questions in the chat. And so again, changing a little bit what our outline was, but taking into account our time. I do want to ask this one that I think is a nice broad question. I'll open it up to everybody, anyone who wants to answer. This is from Mercy. Thank you for sharing your insights. My question is, what is an effective way to persuade non-disabled people who are against disability rights and inclusion? So this nice narrow question. I'm sure we could answer that in about 2 minutes, but if there's anyone who wants to respond to that, because I think generally, and one of the end of the session questions I had raised with folks, I think also was, where do you see disability rights going in the next period? So maybe you can combine those two, and anyone who wishes to jump in and try to answer that, we can try to take that.
One thing I talk to my students about is the conversation, just having a very frank conversation with people about it. It's not whether you are or are not disabled. It's when you're going to experience disability as a result of your age or unpredictable medical crisis. I think the more we can make people see disability as a normal function of life that you're going to run into, I think that helps. Something that I do in the context of accommodations, I start off my lecture on accommodations by having my students brainstorm all of the ways that we make favors or give grace to people in the workplace, or even do things for people that are bad actors. And the example I give is, let's say that there are two employees who don't work well together. Do they have to file a formal accommodation request to never be put on the same team? No, we just let them not work on the same team, even though that may mean they get less work than everyone else. So I think there's quite a bit that the law requires us to do for people with disabilities that we actually just do in general, and this just happens to be formalized. But the better argument is, you are going to experience disability. Someone in your family is going to experience, someone is experiencing it in your life that you don't know. And there's so much internalized ableism that stops people from seeing themselves as being within the disability frame, but they will get there. So let's all fight for our rights together so that you can enjoy them as well.
Yeah, my phrase for this is disability is a club you may be asked to join at any time, right? And so better, but also you point out I'm a sibling of a woman with intellectual disability, and so many people, without going too far from their personal situation or immediate family situation, do have some connection to disability. They don't always know it, but they often do. And what's also interesting about disability rights, this is maybe a partial answer to the question, is it hasn't traditionally fit within the kind of typical left-right way of thinking about rights of marginalized persons, partly because of that very fact that people get touched by disability. So, there's so many stories about, including when the ADA was passed, about, well, why is X, relatively conservative congressman supporting the ADA? Well, because his wife has bipolar disorder, which he's, identified, and so he has an interest in that. And so there's that does mean that some people who would not otherwise, by their politics, be inclined to be supported may become so. It's not a perfect resolution at all, but it does mean that I've always felt that as a group, the disability rights community could probably do a better job of doing that kind of advocacy in politics, otherwise, to make sure you take care of us. That said, it has been the case that disabled groups have often been the most active in pushing back against, for example, proposed cutbacks in Obamacare and in the Medicaid process. So they are out there trying to make themselves heard. And of course, as we also know, many of the statutory and regulatory achievements that have occurred in the field occurred in combination with or in response to political activism, going back to the sit-in at the Regional Office of Health, Education, and Welfare back in the 70s to get the 504 regs passed, or the capital crawl to get the ADA passed. All that has been there. We have a couple of questions that are about regulatory questions, and I'm going to pass on those only because we've really not been dealing with those. There certainly are some, I would say more generally, this is a very broad question, but that there's concern that many of us have that some good regulations are being pushed back or being suspended in some ways, and of course some very bad regulations. Francine mentioned one that our executive order just came out yesterday, which would supposedly make it easier to civilly commit unhoused people who may or may not have mental health or substance use issues. That's been something which the ABA, among other things, has taken a position against. And it is, again, I think, just part and parcel of one can be very cynical about this, because in addition to really using the wrong way of dealing with an ongoing problem, people are not consistent with it, when in fact there might be some things they could do. So, if there's some kind of mass tragedy that occurs, the response, well, it's not about guns, it's about let's spend money on mental health, but then somehow money isn't spent on mental health. We have about 4 minutes, so I just want to, anybody on the panel wish to jump in. The one thing I would say that I think both in some of the pieces, particularly yours, Dee, but also in what people have said today, is that connection between one's own identity as a person with a disability and what is of interest in both in the articles you wrote and just more generally. And so if anyone wishes to speak to that, I think we'd love to hear that.
I'll speak quickly on it because I think it links to the question about persuading those who are against disability rights. To a certain extent, I think we don't have to, because we have the codified ADA, right? We don't have to do too much of that policy battle, thankfully, in order to have rights recognized. But there is still an importance in the changing hearts and minds even after that, as my various identities have taught me with trans rights and Black rights. So I think that coming out about being trans, coming out about having disabilities has been, for me, liberating, and I think for many liberating, right? As Leisha and Jen said, there is no shame in either being trans or being disabled. And I think that the way we start to change how people perceive us is by talking about it as empowering, right? As not a form of suffering, but just as what is, as a part of the diversity of our culture. And I think that's really the disability justice future for me, in a lot of the writing and that I found really inspiring, is trying to reframe how we're conceiving of our identities as, again, all of us being disabled before we pass, and what it means if we were actually to change society in order to get it to accommodate all. So I find that really empowering and encouraging. And so I want to write about it very openly and speak about it very openly. And I think I'm in good company on that score here.
And I will say, again, having looked at this over a period of time, I think more and more people are comfortable with identifying as having a disability. People who are in prominent positions, which can also be affirming for people who are not. We always talk about how it's a lot easier to think of yourself in a certain situation if you can see people like you in those positions and to do that. So, we continue to have many too few lawyers with disabilities, too few law professors with disabilities, too few law students with disabilities, but some of that is changing, and some of it's changing because of work of people like you. It also, of course, is, as some of you may know, July is Disability Pride Month. So in addition to being the ADA anniversary, we're coming up, it's important, I think, that we do that this month. And like other Pride months, it's one where we can celebrate a disability and try to make it clear to everybody why it's something that not just people with disabilities, but everybody should be thankful that we have. So I think we are at the end of our time, and I see Francine, otherwise known as the Grim Reaper, on the screen. So I'm going to turn it over back to you.
I do. Thank you, everyone. This conversation has been phenomenal, and I am in awe of each and all of you. And the only thing that would be better is, as Dr. Powell suggested, this is Friday afternoon. We should have an adult beverage together or even hydrate with some water. If we were in the same room, I would toast each and all of you for your phenomenal contributions. I do just want to give one shout out. Each and all of you listening, you must read this entire issue. While these scholars and advocates' pieces are phenomenal, there's even more in this issue. So go to the website. And just to give a little hat tip to Bob, the human rights hero in this issue, and each of our human rights magazines has a hero, is Claudia Gordon, who is another rock star and role model in the disability rights movement, a lawyer who is very out about her disabilities and engaged in so many different public and private pursuits for equality. So thank you each and all. And this is just the beginning of the conversation, truly. Please, I cannot say enough about this moment in time and this place on earth. The ABA Civil Rights and Social Justice section is your happy place. There are people like these individuals who are writing and thinking and pushing the envelope and protecting your rights. So think about joining us. You don't have to be a lawyer. Go to law school. We got lots of law professors on here. So please have a wonderful and safe weekend, and loud applause for each and all of our panelists. And you have a great